Hey there, I'm the MadCatster. Am I glad to see you here? Well, the fur is flying between Catherine McBroom and the new 1212 Gateway lawsuit brought by TBL Cosmetics, alleging that she didn't comply with their settlement agreement, and Catherine is bitch slapping back. We're going to talk about it. I've got all the latest pleadings, so let's get into it. Good evening, gentle viewers. Well, the claws are out in Los Angeles and they're jungle red. And the first one of you that emails me at realmadcatster@gmail.com down below here and tells me where that reference comes from will get a free Sybil the Enforcer t-shirt. So make sure you pause the video and come back and finish watching it after. As soon as there's a winner, I'll post it on the community page of the channel, and that way you'll know that someone's won. So come back and watch the video if you're going to look it up. Anyway, so the claws are out in Los Angeles, people, and they're jungle red. And Catherine Dolores McBroom is out for some bloodletting of her own against TBL Cosmetics, who is fighting her over 1212 Gateway, the cosmetics company that she started with them. And they came back at her because the lawsuit, many of you remember, was filed last year against Catherine, was settled in a confidential settlement agreement where Catherine and TBL agreed to do certain things in order to end the lawsuit and try to bring everybody back together to make the company a success. TBL alleges that Catherine did not comply with her part of the agreement, and they brought a new lawsuit earlier this year. And Catherine has now slapped back, and she has filed a cross complaint, which is basically a lawsuit within a lawsuit, where if someone sues you and you think you have claims against them, you could file a cross complaint, and it's all litigated in the same lawsuit. So Catherine has basically filed a lawsuit within a lawsuit against TBL, stating that they did not comply with what they agreed in the confidential settlement agreement, and calling them all sorts of nasty names. And I'm going to talk to you about it now and let you know what the issues are and who said what and alleges who did what to whom. So here we go. So you can see in here, the first thing I'm going to cover is Catherine has also filed what's called a motion to strike, and she's alleging that some of the things that were said in the new complaint filed by TBL are unkind to her, and she does not like them, and so she thinks they're not relevant to the lawsuit and should be removed. And I'm going to explain to you what she's talking about. Sybil the Enforcer is here, and she says, I know each of you who's not subscribed, and I've promised her that she will get a promotion. So help Sybil out. Make her a happy kitty, and she will reward you with some purrs. I don't know if you can hear that. Anyways, so like and subscribe, people. I know half of you are not subscribed. Shame on you. Subscribe. Make this kitty happy. Thank you. So anyway, so here is what they filed. It's called a motion to strike, and I'll show you what she's saying. So here's her motion to strike. Now remember, she and Austin are defendants in this lawsuit. So defendants hereby move to strike the following portion of plaintiff's complaint in order to remove irrelevant, false, or improper matter inserted in the pleading, and to strike any pleading or part thereof not drawn or filed in conformity with the laws of the state. So basically what they're saying is you're allowed to ask the court in most states to remove material that's contained within a complaint that's not at all relevant to what's being alleged, to the main thrust of the complaint. So what Catherine is saying is there's two paragraphs that she doesn't like what they say. Paragraph 33, where it says, all technology, passwords, and logins of 1212 Gateway that had been improperly taken over by McBroom were returned to TBL. And paragraph 35, TBL was hopeful that the impact of Ms. McBroom's takeover could be mitigated and the company could get back on track for success. So basically they're saying, wah, you're calling Catherine names, we don't like it, we want this stuff taken out. So what's also interesting is they're saying that these issues that are being raised in this second new lawsuit can't be raised because if you look down here, their argument is once they did the settlement agreement, part of that was that TBL Cosmetics agreed to dismiss the first lawsuit with prejudice, which means you can never bring a suit again for those same issues and same facts. And their argument is, well, some of these things that you're raising in the new complaint, you can't because they were raised in the old complaint, and the old complaint was dismissed with prejudice. Well, that is correct. However, if Catherine failed to comply with the terms of the settlement agreement, she can't then go back and say, well, that you can't because you dismissed that with prejudice, because if you didn't do what you were supposed to do, then you violated the settlement agreement, and the settlement agreement should be null and void. So yes, they can bring it up again. So now let's talk about the cross complaint. So now Catherine, after they alleged she didn't do what she was supposed to do, she's now come back and she's throwing it back in their face. And you can see here, it says defendant's cross complaint and demand for jury trial. She's alleging breach of contract, fraudulent inducement, breach of fiduciary duty, and unfair competition in violation of California law. So what is she alleging? So she's saying that the lawsuit centers around the clear breach of the material terms of a settlement agreement. When I say lawsuit, it's the cross complaint, not the main TBL complaint. It's Catherine's cross complaint. This lawsuit centers around the clear breach of the material terms of a settlement agreement between Catherine McBroom and her unscrupulous business partners related to a skincare company called 1212 Gateway that Ms. McBroom founded and single-handedly propelled to a stunningly successful initial launch. So basically, Catherine's calling them names, and I would think they could file a motion to strike that because that just sounds like name-calling unscrupulous business partners. And I love how she takes all the single-handed, like TBL had nothing to do with it, you know? Like she magically created this product and she made it a success. Then why the hell would she bring TBL into it if she's so successful? They're the ones, from my understanding, whose scientists created the formulas. So Catherine didn't single-handedly do anything, in my opinion. So they go on to say, Ms. McBroom is a leading social media influencer, known to her legions of devoted followers for her family-friendly content. Family-friendly. I'm sure plenty of you watching, dear viewers, could tell me numerous examples of content that they've put out that is not family-friendly. And promoting illegal gambling, in my opinion, is certainly not family-friendly. So she really thinks highly of herself. Despite the strength of her fan base, Ms. McBroom had never launched a business prior to launching 1212 Gateway. And despite cross-defendants' incompetence, meaning TBL Cosmetics, the business has amassed nearly 400,000 followers on Instagram. Okay, I'm just going to stop right here. You all know that does not translate into sales. I don't care if she has 4 million. We know that there's allegations that they buy followers. Even if they have 4 million followers on Instagram, all that counts is the bottom line. If you're not making sales, I don't care how many followers you have. So I don't know why they point, they have a habit of pointing to these esoteric numbers that are not grounded in any kind of reality in terms of cause and effect. So she goes on to say, as a result of her marketing efforts and the use of her likeness, she's gotten these 400,000 followers. Well, okay, meaningless. Shockingly. Even though Ms. McBroom was the face of the brand, TBL filed a lawsuit against Ms. McBroom in Los Angeles Superior Court. So, shockingly, even though she wasn't doing her job, they allege, she was shocked that they filed a lawsuit against her. The nerve. So, I'll skip over some of this irrelevant stuff. So what she's saying, now she starts really calling names at TBL. This is what she says about TBL. TBL is, and at all times herein mentioned, was a mere shell and shame without sufficient capital or asset. TBL was conceived, intended, and or used by, and these are the principals from TBL who are involved with 1212 Gateway, Rice, Eisner, and Engfer, as a device to avoid individual liability and for the purpose of substituting a financially insolvent limited liability company in their place. TBL isn't at all times was so inadequately capitalized that compared with the business to be done by them and the risks of loss, their capitalization was illusory, meaning it was non-existent. It was a mirage. Rice, Eisner, and Enger and used assets of TBL for personal uses. Now, she's talking about TBL, not 1212 Gateway. she doesn't have any standing to bring any kind of accusation against TBL unless she's a shareholder. She's alleging these things about TBL when it has nothing to do with her interests in 1212 Gateway. She has no interest in TBL as far as I understand. Rice, Eisner, and Enger used assets of TBL for personal uses, caused assets of the limited liability company to be transferred without adequate consideration, and withdrew funds from the company bank accounts for their personal use. Again, TBL is not 1212 Gateway. The company that they have shares in together is 1212 Gateway. That should be her focus. What's going on at TBL is really irrelevant to the accusations and allegations that have been made. So she also says that they controlled, managed, and operated TBL and intermingled company assets with each other and their own to suit the convenience of themselves in order to evade payment of the obligations owed to creditors of TBL. Again, it's not relevant as far as 1212 Gateway goes. She's not a shareholder of TBL. TBL is in all times herein mentioned was controlled, dominated, and operated by them in that the activities and business of TBL was carried out without holding company. Again, she goes on and on and on, and they're slamming TBL. And then if you read further into her complaint and the counts or the claims that she is making with regard to this business with 1212 Gateway, none of this is relevant to that. And if I were them, I would move to strike all of this, because she's not a shareholder of TBL. TBL is not what's at issue here. It's what's going on with 1212 Gateway. So I think this is all just name calling and speculation, and I think it's just irrelevant to this particular lawsuit. So anyway, TBL may end up asking that this be stricken from this. So now let's go to what she's actually claiming, and you'll see it has nothing to do with what I just read to you. So she says, in order to protect her significant brand goodwill, Ms. McBroom is exceedingly selective in her business relationships, and was all the more so with regard to the first business endeavor she herself launched. Well, exceedingly selective. Okay. Ludi.com. I guess she's really exceedingly selective going with Ludi.com for a business relationship and a sponsorship. So, and all this stuff with, what was it? Sticky Juice or Sluicy Juice? What was it called? Silly Juice, that fell apart, and all the other business ventures. She's very selective in her business relationships. Yes. Okay. Whatever you say, Catherine. At the time 1212 Gateway launched, the board consisted of 2 designees from McBroom and 2 designees from TBL and 1 independent board member. So basically, from what I understand, there were 2 people from TBL, there are 2 people, Catherine and Austin McBroom, and then there was 1 independent person. And that way, if there was a disagreement between the 2 and the 2, the 1 independent person could break the tie. So she claims that they were unable to agree on an independent designee. And this was back before the first lawsuit was filed. Then she goes on to talk about how on August 30th, 2021, Ms. McBroom and Mr. McBroom, on behalf of the McBrooms and Ian Rice on behalf of TBL, in order to settle the initial action, executed a confidential settlement agreement and release. And we know that. And that's why the lawsuit was dismissed. So these are the terms of the agreement she's claiming TBL is not keeping up with. And mind you, what TBL said in this original complaint that this is the cross complaint to, they're saying that 1212 Gateway was never actually a party to the settlement agreement. No one in the capacity of a director or a manager of 1212 Gateway actually signed off on the agreement. So the agreement was really between TBL and Austin and Catherine McBroom. So what TBL is saying is 1212 Gateway has a say if the agreement isn't going the way it's supposed to, because it wasn't a party, but consequences directly affect the business. So, but we'll get to that in a second. So the parties shall direct 1212 Gateway, parties being all of them, TBL and the McBrooms. The parties shall direct 1212 Gateway to engage Gary Sanger, who is like an outside recruiter from what I understand, within 10 days of the execution of the agreement, to provide 3 qualified independent candidates with experience in the cosmetic and skincare industries for the position of independent designee. So for the open independent board member, 1212 Gateway is supposed to engage this recruiter to find them 3 board candidates who are independent, who have experience in the cosmetic industry, so they can all decide on one that can fill that position. Okay. The candidate presented must be within 60 days of engagement, and there should be a report detailing any conflict of interest. One of the candidates shall be a woman or a minority. If the board members are unable to agree on a candidate, and remember there's 4 of them, it's very possible they won't agree, within 7 days, then the matter shall be submitted to arbitration. Then an independent arbitrator will decide who's the qualified candidate in order to break the stalemate. So it goes on now. Now remember, the settlement agreement was confidential. It was not filed with the court. So we don't know all the contents, and we're kind of gleaning bits and pieces from what's being said in these lawsuits. It goes on to say that 1212 Gateway also was supposed to engage a new corporate counsel firm for 1212 Gateway, and there are 2 candidates listed here. They also said that 1212 Gateway shall seek to engage one of 2 CPA representatives to handle the finances. Then they say, TBL, based on all these things they agreed, TBL filed a request to dismiss the initial action with prejudice on September 1st, 2021. And we know that. So now what you've got to keep in mind is they keep saying, and correctly so, that in the agreement it says 1212 Gateway shall. Now, 1212 Gateway is not TBL Cosmetics or just the McBrooms either. It's a separate entity, and decisions are made by the board, and there are 4 board members currently. I looked at the operational agreement for 1212 Gateway, and it says right in there that all the board members are operating as a board of managers. Therefore, that just adds further support to what I was saying. She can't accuse 2 of the 4 board members of not doing what the whole company board was supposed to act on. Now, that's interesting because now listen what she accuses them of. She says that the McBrooms had performed all of the duties required of them under the settlement agreement. They say that TBL breached their duties under the agreement by... this is where it gets interesting in what I'm talking about. She claims that TBL breached their duties under this agreement by failing to engage Gary Sanger, the recruiter, to find 3 candidates to serve as independent designee to the board, failing to seek to engage the law firm as legal counsel, and failing to engage a CPA. Now, this is what doesn't make any sense. As I said, TBL Cosmetics was not the one who was charged in the agreement to do this. 1212 Gateway was supposed to do this, which means Austin, Catherine, and the TBL representatives were supposed to do this as a board. So she's accusing TBL of not doing this, but she's basically accusing herself too, or admitting that she didn't do what she was supposed to do, because the person or the entity that was supposed to do the things she's saying didn't get done is 1212 Gateway, of which she is one of the 4 board members. So it makes no sense. She goes on. She says that Catherine and Austin have suffered financial and reputational harm resulting from the absence of a functioning board to oversee Ms. McBroom's first business endeavor. She keeps saying that, I don't know. She pats herself on the back every time she says it, I guess, as well as from the absence of the agreed upon corporate legal counsel and corporate accountant. But again, she's only got herself to blame for that if it didn't get done, because it wasn't TBL's responsibility. It was 1212 Gateway's responsibility. So if it didn't get done, then there's the 4 board members to blame, not just the TBL people. Cross-defendants, TBL's breach of the agreement by failing to properly engage the recruiter in order to locate candidates, failing to engage the corporate attorney, and failing to engage a CPA was a substantial factor in causing their own harm. So what she's saying is their failure to get these people appointed was a large factor in causing the harm that they claim in their second lawsuit against Catherine, what they're claiming they suffered. She's saying that was mostly their own fault, is what she's saying. And then she's alleging fraud in the inducement, and she's saying that the cross-defendants TBL represented that they would engage the recruiter to find a candidate for independent board member within 10 days of the execution of the agreement. They represented that the candidates would be presented to the parties within 60 days of the execution of the agreement. TBL further represented to the McBrooms that TBL would seek to engage corporate counsel and a CPA. Well, again, it's not TBL who is supposed to be doing this. It's 1212 Gateway that's supposed to be doing this. She also says that TBL knew that the representations were false when the agreement was signed, and they didn't take any steps to engage any of the people that they were supposed to, and that they took no steps to present the independent candidate. And she's saying basically that they did this on purpose. She's saying that she has suffered financial and reputational harm because of the absence of the functioning board. Again, she's saying the same thing, to oversee cross-complaints first business endeavor, as well as the absence of corporate counsel. Okay, so again, she's making accusations allegations against TBL, but really the fault lies with the board of 1212 Gateway. So the fault for the things that she's claiming have hurt her is due to the failure of the board of 1212 Gateway to do what the parties had agreed. So again, it's very confusing. She's alleging that it was their responsibility to do this, not saying that it was her responsibility or that she failed to do this. She's making it sound like only the TBL people were supposed to do all these things. Well, that's not true. If it says 1212 Gateway, it means the whole board was supposed to do this. And she's saying, I didn't have anything to do with it. They were supposed to do it. It's like, well, no, they weren't, Catherine. You were all supposed to do it. It's you too. You and Austin failed to do it too. Because the four of you as 1212 Gateway were supposed to do this. Not just the two people from TBL. You're basically saying, I don't have to do anything. You were supposed to do all the work and you didn't do it. And now you've hurt me. Well, no, if you didn't do the work, then you hurt yourself. Then she claims a breach of fiduciary duty. And what she's saying is they acted secretly and for their own interest to prevent the search for a qualified candidate for the position of independent board member and to prevent the retention of the agreed upon counsel and CPA, and that this was a breach of material duty existing between TBL and the McBrooms. Well, she doesn't specify how they acted secretly and for their own interest to prevent the search. What the hell does that even mean? What does she mean secretly? She knows or claims that they didn't participate in this process or they didn't do. She's basically saying they didn't do this. So why is that secret? It doesn't sound secret to me. If the terms are spelled out in the agreement and the conduct or the actions that we're supposed to have taken were not taken, that's not a secret. It clearly didn't get done. What's the secret? I don't get it. She doesn't specify. If it's a breach of fiduciary duty, well, like I said, it's all four of them who are responsible, not just them. And again, she's trying to point the finger at just half the board and not the whole board. And in fact, it's the whole board that's responsible. Then the last thing, and this is a thing that I want to talk about too. This is kind of weird. Okay, so they're saying that unfair competition under California business and professions law against the TBL people. She's saying that the TBL people committed unlawful, unfair, or fraudulent business acts by breaching the McBroom's contract with TBL, making intentional misrepresentations that harmed the McBrooms and breached the fiduciary duties owed to the McBrooms as a partner. These unlawful, unfair, fraudulent business acts cause cross-complainant to suffer financial harm and undermine 1212 Gateway's capacity to compete as a business entity. Now, I personally, having reviewed the California statute, and I'm going to put it up here so you can see this, I believe that they are misconstruing or misunderstanding what the law says. So I'm going to put up here, this is the part of the California code that the McBrooms are alleging the TBL people violated and caused unfair competition. Now you'll see what I mean. I don't think they're interpreting this statute correctly. So it says, as used in this chapter, unfair competition shall mean and include any unlawful, unfair, or fraudulent business act or practice, and unfair, deceptive, untrue, or misleading advertising, and any act prohibited by this chapter 1 of the Business and Professions Code. Now, if you go down further, there's another part here. It says, this is how you kind of get an idea of what the meaning of the statute is and what they're talking about when they say unfair competition. Under this injunctive relief section, it says, any person, meaning not just a person, human, but corporation too. Any person who has engaged or proposes to engage in unfair competition may be enjoined in any court of competent jurisdiction. So when they say unfair competition, the McBroom's lawyers have latched onto the part about the unfair and deceptive acts. But in order for there to be unfair competition, they would have to be basically, for example, TBL would have to be launching a competing business and trying to undercut their interests in their partnership with the McBrooms, or making a deal with somebody else that injures the ability for that partnership to flourish. It's unfair competition. So they're not, as far as I can see, engaged in unfair competition. They may have done some things you don't like or disagree with or that you think are unfair or deceptive, but they haven't engaged in unfair competition because they haven't gone outside of the relationship and engaged in something that's going to harm your business relationship with them and the partnership you have. So I don't think they've construed this law correctly and interpreted this law correctly. I think that they latched on to the part about unfair and deceptive and just totally skipped the whole part about the fact that there has to be unfair competition. And those acts, deceptive acts, are part of the unfair competition, but I don't see any unfair competition. I don't see any competition outside of 1212 Gateway at all. So they haven't alleged it or pleaded it in their complaint. So I don't know what they're talking about. I don't see any unfair competition. So they're calling names at each other. They're saying Catherine didn't do what she was supposed to do as part of her agreement in Austin as well. And from what I understand from the agreement they had, that Ace Hat Collection, these are the McBroom's like merchandise company for their YouTube channel, was supposed to handle fulfillment and customer service for 1212 Gateway. And that way, I guess, give business to Ace Hat Collection. Who knows what that was supposed to be all about? You know, I didn't realize that that company had the kind of infrastructure to do all this, but whatever. So they may have just done it to placate the McBrooms. They're saying Catherine didn't do her part in marketing the business. And I think that that's pretty evident because any of you who have seen any of her posts, I've never seen her since all of this happened really talk about 1212 Gateway or the product lines. So you know, if that's what was in the agreement, we don't know because we haven't seen the actual agreement. But if that's what's in the agreement and she's not been promoting it, then she hasn't been doing what she's supposed to do. And so what she's come back and says, well, you two didn't do what you were supposed to do, which was everything else in the agreement. Well, that's not true because they can't unilaterally hire these people that were supposed to get hired, the CPA and the corporate counsel. They can't unilaterally pick candidates or select candidates for the independent board position. All four of them would have to come to an agreement in order for those things to get done with the business. So I don't really quite understand how Catherine is making her argument because all of the things that she's accusing the TBL members of the 1212 Gateway board of not doing were things that 1212 Gateway as a company was supposed to do. So if the four board members didn't agree on this stuff, I don't understand how Catherine can absolve herself of any responsibility for those things and put all the blame on the two TBL members. She and Austin are supposed to be actively participating. And in fact, in TBL's lawsuit, they're saying Catherine's not even coming to the meeting. She's sending some other guy as her proxy. So Catherine's not even, it's like she doesn't really care. Is my opinion, and my impressions, is that Catherine just doesn't really care. She doesn't want to really be involved with the business, and yet she's going to sit here and say, oh, the business isn't doing well because you guys didn't do what 1212 Gateway was supposed to do, even though Austin and I are half of 1212 Gateway. And actually, they have a bigger financial interest from the documents I looked at than the two TBL people do. So, Catherine and Austin, where have you been? You know, you need to step up. You can't just say, oh, you guys are supposed to do it all, and we're just going to sit back. The four of you are supposed to run this company as board members and make decisions. So you haven't done that. You can't blame just them. And in my opinion, I don't think her cross complaint has a snowball's chance in hell of winning. And I hope for their sake, after they do some discovery, that they file a motion for summary judgment or motion to strike even, because the counts and the claims are one thing. That's the heart of her cross complaint. But all that, basically all the shade she threw at TBL, that has nothing to do with 1212 Gateway's operation. So I don't know why she put all that in there, whether just to, you know, spite them or get back at them. But then she's guilty of doing what she's accused them of in her motion to strike. And she's put all this irrelevant stuff in there. So they may end up filing a motion to strike part of Catherine's cross complaint. I'm assuming will file a motion for summary judgment after they've done discovery. So we'll have to wait and see. But I thank you guys for joining me. I thank you guys for helping us grow. I wanted to also say, again, I said it in the last video, I've refreshed the Amazon wish list. I did not realize, I said this before, I did not realize that Amazon was removing items that people were sending from the list. So, because when I look at it, I just see the whole list. So I've changed that. So, because the things that are on that list are stuff we use all the time. It's not just stuff that we needed one of. So I've put it all back the way it's supposed to be, and it will not come off at this point. But if there are things I think we have enough of, I will remove those. And in fact, there are a couple things I did remove because we don't need any more. But if any of you had looked and saw that the list was empty, I apologize. It's all there again. So if you do want to send something from the Amazon wish list, the link is down below in the description. Thank you to my Patreon patrons. Thank you so much to my channel members. And thank you to all the people who bought me a cup of coffee. All of you are wonderful. You've helped to make this channel a growing success. You've helped to make this community what it is, all of your comments and participation. We are going to be doing another live stream. I think all of the issues are resolved with live streaming. I had to switch back to cable internet. I didn't want to, but what was happening, I think, was that the 5G was really good for streaming. Like, my whole house runs on streaming, and I was having no issues. But for some reason, the upload is hitting a brick wall. And I think it fluctuates with the time of day, but I obviously can't do streaming if I'm going to have a problem uploading. So I've switched back to cable internet. I haven't canceled the other one yet because I want to be certain that that's what's going on. I'm going to do a test run this weekend to see if I'm correct that that was the problem. And if so, then I will cancel the other one because I do want to do live streaming. And if it means going back to cable, then it means going back to cable. I will let you know when the next live stream is. I will post it on the community page. So take a look. Be looking for that at the end of the weekend. Thank you so much again. You all take care of yourself. Sybil says goodnight, and like I said before, she's gone rushing back to bed. But look who's here for a treat. It's my little Squirt. Say hi, Squirt. So this is Olivier, but I call him Squirt. I've never called him Olivier. He's a little antsy. He wants to go to bed. And so he's sitting. He's so cute. He's my little buddy. He gets so excited when it's bedtime. I go up and he's on the bed and he's pacing around and he's going meow, 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 meow. And he like rolls over and he rubs against me and he loves to go to bed. And when I go to bed, he comes and he sleeps on my pillow and he needs a pillow for like half an hour while I'm trying to watch TV. But he's very cute. He's my little buddy. Him and Sybil, they're both like attached to me at the hip. But thank you again. You all take care of yourselves. I will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.